And the topic is not only a profile of Attorney Blackshear, but also African Americans and the law. And of course, Attorney Blackshear, before we had our first commercial break, you were talking about some aspects of the law and how the law is applied, and that essentially law is what people say the law is. Go on and let's continue that discussion.
Well, what I was, the thesis that I'm trying to establish here is that the law is ubiquitous, it's in everything, we cannot escape its consequences and its effects. So the survival of a group of people in this country, whether that be Hispanic, whether that be Black American, or white American, or Irish American, or whatever, depends upon the extent of that person's presence with the law. We as Black Americans need to be involved in the making of the law, as well as in its implementation.
Okay.
Consequently, we should encourage each other to run for political office, because we can influence the development and making of the law by being legislators. We need to encourage people to become lawyers, because now we're involved in the implementation of the law to make sure that an otherwise legitimate law is still not unconstitutional and misapplied, you see. And that is the role, and that's the challenge that we all have. Realizing that the law itself has that much impact upon the quality of your life, then you need to be in a position where you can influence its development and influence its implementation, so that you can have something to say about the decisions that are going to affect the quality of your life.
You know, I think when we talk about the law, and I think you mentioned earlier about the law before 1865, and you talked about contract law and the whole issue of slavery. Let's develop that. Let's talk about that.
In common law England, the one criterion that distinguished a freeman from a serf or a slave was the ability to make and enforce contracts, to strike your bargain with other people without unreasonable restrictions by any government. Slaves could not engage in contracts, but freemen can. So during the time of slavery, in fact, let me just say this: this characteristic of a freeman is been emphasized to such a great extent that when the Constitution was formed, the impairment of contracts clause was placed in this Constitution, where people constitutionally in the United States have the right to make and enforce contracts without unreasonable interference on the part of government, recognizing the significance of having that ability. Now, during the time of slavery, what made Black people in reality slaves is that they were prohibited from having the right to make and enforce contracts. Now, after slavery, 3 amendments were passed. The first amendment that I want to refer to is the 13th Amendment. You notice the 13th Amendment abolishes not only slavery, but abolishes the badges and incidents of slavery. Badges and incidents simply means characteristics of slavery. The right to be prohibited from making and enforcing contracts is one of those characteristics of a slave. So the 13th Amendment not only abolished involuntary servitude, but it abolished those things that were related to and grew out of involuntary servitude, such as being prohibited from making and enforcing contracts. The United States Congress, in enabling the 13th Amendment, passed a law quite some time ago, found in Title 42, United States Code, Section 1981, and it says, Black persons shall have the same rights as heretofore provided to white persons to make and enforce contracts. Therefore, we ask ourselves the question, why is it that a private school can prevent Black people from admission? Well, it cannot, because under the 13th Amendment, as enabled by this law that I provided to you, says that if Black kids who are trying to enroll in a private school are prevented that opportunity to do so because of their race, then that Black kid is being denied the right to make and enforce and engage in a contractual relationship with that school solely because of his color of his skin and his race. And the 13th Amendment says that characteristic of slavery has been abolished along with involuntary servitude as well. So what is it that makes us free? Not to remove the shackles from our wrists or from our ankles, but to be provided the characteristic of a freeman, the right to strike my bargain,
and make a contract,
and the right to engage in contracts, social contracts, religious contracts, business contracts, any kind of contract without unreasonable governmental interference. Now I can say I have some control over the decision-making process that determines my life. I'm more than equal. I now have some power to take. I can now say I'm free.
And that's all within the 13th Amendment to the Constitution.
That's the 13th Amendment, read in parent material with the impairments of contract clause. So it's about recognizing first what is the characteristic of a freeman in order to know the extent of how the 13th Amendment should apply. If you say to abolish all the badges and incidents of slavery and you not knowing what those are, then you don't know what has been abolished. The secrets, the answers to those questions are found in English history, simply because it is the English history and the legal system in England that was transported over here in the United States. So that's the criteria we look to in determining the differences between a slave
and a freeman. Very good. You know, let's look at some of these other amendments, since you've opened up such a consciousness and such a view on the 13th Amendment. What about the 14th Amendment and the 15th Amendment, and especially the 15th Amendment, because there's been some kind of discussion, and I'm sure you're aware of it, on the internet and other places in reference to the African Americans' right to suffrage. And of course, we've got our second commercial break coming up here, after which we will come back and we will talk about that. But let's look at that. First of all, let's get some kind of definition of that amendment, the 15th Amendment, and then we'll have a break and we'll come back and talk about it.
Okay. Well, could I talk about the 14th
just
go into the 15th?
The 14th.
Well, as it relates to black people, the two basic provisions of the 14th Amendment would be the Due Process Clause and the Equal Protection Clause. The 14th Amendment is the first effort by the Constitution of the United States to tell states what they cannot do. The Bill of Rights limited federal power. For the first time, the 14th Amendment now limits state power. And it says, no state shall deprive a person of life, liberty, or property without due process of law, or deny unto them equal protection of the law.
And let me interrupt here for our second commercial break, and we'll be back with you following this short commercial break. Thank you for the